This is Paul Turner, the Immigration Barrister at Imperium Chambers. Thank you for tuning in. Please subscribe to my channel, and if you have an immigration problem, please get in touch with me no matter what it is, and I'll do my best to help. Today I'm going to be outlining briefly how you can apply for leave to remain or enter the United Kingdom as a partner or spouse. So over the course of the next couple of videos, which I will be uploading shortly, I will be addressing different routes for settlement in the United Kingdom. So I thought that what I would start with is one of the most common ones, which is focusing on the partner or spouse route, which is a route which can lead to settlement in the United Kingdom. Now, looking at an overview of the picture, in order to qualify under this route, there are some fundamental requirements that you must meet at first. If you don't meet them, then you're simply just not going to get the visa. Firstly, the spouse and partner should be over the age of 18. This is because years and years ago there were some very young marriages, and so they put a stop to that. Secondly, the applicant's partner or spouse should either be a British or Irish national, that's another key point, or they should be someone that's settled in the United Kingdom. That could be in the form of having indefinite leave to remain, settled statements, or proof of permanent residence or right of abode. Or alternatively, if the person is from the EU, they must have arrived in the United Kingdom before the 1st of January 2021. That reflects Brexit. Or the sponsor is a refugee, and I'll come to the refugee family reunion point later on in this video, or they have a Turkish business person visa or Turkish worker visa. This is something that is often overlooked but is quite important. So that's the outline and the basis of these requirements that are needed in this to qualify as a spouse or partner. It is very important that the applicant and their partner or spouse have the intention of permanently residing in the United Kingdom. That's a key requirement for this route. There's also some pleasing news that have partners that have settled or pre-settled status, as the applicants in those cases will be eligible to apply for settlement under the EUSS scheme. So unlike other people that will have to pay the fees, if you've got settled or pre-settled status, you'll be exempt from the fees. So in respect of the EUSS, if you have settled or pre-settled status and you're looking to bring your partner over, then I'll be covering this in a separate video covering the EUSS. Now, let's just turn to the requirements that are needed in order to qualify for a spouse visa. Well, the applicants and their partners should be mindful that they must prove one of the following things to be fully eligible under this category. And some of the examples of what they must prove is that you are in a civil partnership or marriage that's recognised in the United Kingdom. So some marriages, such as Islamic marriages and what have you, are not recognised in the United Kingdom, and that's an important point to bear in mind. If you've been cohabiting, then you've got to show that you've been cohabiting for at least 2 years when you apply. Or there is another route into the United Kingdom, which is that of a fiance or proposed civil partner, and that you will marry or enter into a civil partnership within 6 months of arriving in the United Kingdom. So that's a third way in, but you have to have the intention to get married. The applicants will also need to prove that they have a good knowledge of the English language. I'll come to that, both listening and speaking. They will also need to show that they can financially support themselves and their dependents. This will mean in practice that they will need to meet the financial requirements. Currently it is for a spouse £18,600 a year, with an additional £3,800 for your first child and a subsequent £2,400 for any other child you have after that. It will also be necessary in spousal applications other than refugee family reunion applications that the adult partner or spouse speaks English to the A1 standard and will need a secure English language test result for that. It's not a particularly hard test. It will also be necessary for you to show that you've got sufficient accommodation. If you've got a large family and you've only got a one-bedroom flat, you'll have problems, for example. It will also be vital for any application that the specified documents that the Home Office has set out in the relevant appendix are complied with. I'll come to those documents in a different video, in a more detailed video, but if the documents are missing, then the Home Office will likely or could refuse the application. So it is vital that the exact documents requested are provided, and if you choose me, I'll tell you what they are. This provides an outline for what would be a normal partner application under the immigration rules. Having said this, this is not the end of the matter for those that want to stay in the United Kingdom. For those individuals that do not qualify by meeting these requirements, there are other ways that you may still be able to get a visa or extend your permission to stay in the United Kingdom if you can show one of the following. For example, if you have a child who is in the United Kingdom who's a British citizen or an Irish citizen, then you'll be fine. Or if you have a child that's lived in the United Kingdom for 7 years, then the child will qualify for indefinite leave to remain under the new concession and you'll be granted a visa. Or alternatively, there will be very significant obstacles for you and your partner that could not be overcome if you had to live together as a couple outside the United Kingdom. This is much harder to prove. Or alternatively, and this is the last thing, it would breach your human rights to stop you coming to the United Kingdom or to force you to leave the United Kingdom. So these are the outlines. So if any of you wish, who's watching this, to apply as a fiance or proposed civil partner, they must prove that any previous marriages or civil partnerships have ended and that you plan to become civil partners or marry within 6 months of coming to the United Kingdom. Now, one of the other critical questions that the applicants or viewers may have is, how do I prove my relationship? It's very easy to say that you're in a relationship, but how do you prove it to the satisfaction of the Home Office? Whilst making the application, it's important to provide sufficient and supporting evidence that shows that it comes from a government body, a bank, a landlord, a utility provider, or a medical professional. Evidence that confirms your relationship with your partner. For example, that you live together, that you share expenses, or are married or in a civil partnership. And the supporting evidence needs to be less than 4 years old. That's for obvious reasons for people who perhaps relationships are broken down. So the evidence needs to be fairly relevant. You can use documents such as, and this is probably one of the key documents, a marriage certificate or a civil partnership certificate, again, one that is recognised in the United Kingdom. That sets up a prima facie case that you are in a relationship. A tenancy agreement, utility bills or council tax bills confirming that you live together or pay bills at the same address, so that you're living together and not just in some sort of marriage of convenience. A bank statement from a joint bank account or confirming that you live at the same address. Again, this shows that you're actually in a relationship and you haven't just entered a marriage to get a visa. Letters from a doctor, dentist or GP confirming that you live at the same address will also do the same job. If you do not have any of the evidence that I've just outlined above, there is other evidence that you can provide instead. However, it is noted that this form of evidence may have a little impact on your application. So it's worth bearing in mind that if you can get the proper evidence, you will have a better chance of success. Some of the alternative evidence can include, and I'm not joking, a one-off vets fee or home repairs costs, letters confirming that you and your partner are on the voting register for the same address, student finance paperwork confirming that you live at the same address. There is other evidence that is often useful in supporting such an application, such as greeting cards, travel tickets, receipts, photographs, text and social media messages, are not considered particularly strong evidence of your relationship, and while they'll help the application, on their own they're not likely to determine it in your favour if you don't, say, have a marriage certificate. You can also switch into this route if you're currently in the United Kingdom, say, as a Tier 2 migrant, but you can't switch into this route if you're, say, a visitor. Unfortunately, the Home Office would require you to leave the country. Now I'm going to turn to the family reunion policy. It's worth noting the family reunion policy as well, as this policy enables family members of a person who has been granted refugee status or humanitarian protection in the United Kingdom to be reunited with their family member. This provision applies to spouses and partners or children under the age of 18 who form part of their family unit, and this is crucial, before the sponsor had to leave the United Kingdom. In spirit, the caseworker must be satisfied that the sponsor has refugee status or humanitarian protection in the United Kingdom, and this can be done by showing that the person has a letter saying they're a refugee or a BRP. The applicant is related to the sponsor. Again, we come back to the marriage certificate or evidence that the relationship exists. And this is crucial, that the applicant became part of the family before the sponsor had to flee the country. So you have to be in the relationship before you come to the UK, not meet somebody after you've been recognised as a refugee. Applicants will have to submit all original documents, from establishing their identity to providing supporting evidence to establish the relationship with the sponsor. And some of the documents that can be submitted are as follows, and I give these as examples. Passports, national identity card, any other official document, for example, school ID cards or letters, or evidence that the applicant and the partner have a valid marriage or civil partnership. And obviously this is going to be one of the most important documents you can provide. Evidence to show that the relationship is genuine and subsisting, so it's carrying on, and evidence to show that each of the parties intend to live together permanently with the other, and this can be provided by way of statements, which I can help with if you choose to go down that route. Now, turning to some of the general questions that people generally tend to ask me in respect of this sort of application. I mean, the first question is, well, how long if I'm granted leave, will I be granted leave to stay in the United Kingdom for? Well, if you apply on the basis of being a spouse or partner, and you've already got leave, you will be granted leave under the 5-year route, and initially you'll get a visa for some 2 years and 9 months. You can then renew this when the visa expires. Next one is, does the same thing apply to a fiance or proposed civil partner? Well, no. In that case, because it's proposed marriage or civil partnership, the Home Office have limited it to a 6-month visa. And the difference is that under that fiance visa, you're not allowed to work, you don't have the same rights. Now, the next thing is, how long would the applicant have to be on this route to be eligible for settlement in the United Kingdom or get indefinite leave to remain? Now, if you apply and you do have leave to remain, you can apply for settlement after 5 years, continuously living on the family visa route. So you're put on what's called the 5-year route to settlement as opposed to the 10-year route to settlement. Another question that's often asked is, can I add, I've got dependent children, can I add them to the application? Yes, absolutely. You can add a child as a dependent if the child is under the age of 18 at the time of applying, or 18 when they were first granted leave. Secondly, and this is very important, it must be shown that the child does not live an independent life. In essence, you need to establish the child is still dependent upon you for basic needs and necessities. It's no good if your child's got married at the age of 16 and has children of their own and lives somewhere else. Another question which happens quite a lot is, for people, especially if they don't have a lot of money, is, I can't afford the fee. What can I do? Am I barred from applying for an application for a spousal visa? Well, actually, you can apply for what's called a fee waiver on the basis that the applicant does not have a place to stay or can't afford it. The applicant has a place to stay but cannot meet his or her basic needs. And the applicant has a very low income, and paying the fee would affect say, a child's welfare. In essence, the relevant test is whether or not you can afford the fee. And if you can't afford the fee, you'll need to evidence it. And generally, you'll need to make what's called a fee waiver application, get that approved before you submit the application. There's no point submitting the application if you haven't been approved for a fee waiver first. So this is briefly outlined, and I'll provide a more detailed video with some graphics and what have you in the future as to what is required for the partner or spouse or fiance route to the United Kingdom. I mean, it is probably the most common route for people that want to come to the United Kingdom. There is one final thing I would say, which is that if you're in the United Kingdom and you don't have leave to remain, and you're granted 2.5 years leave to remain, and you're put on the 10-year route, that's generally because you don't have immigration status when you make the application. However, if the Home Office then grant you 2.5 years on the 10-year route, because you have leave to remain, you're able, as soon as you get your leave to remain on the 10-year route, to switch into the 5-year route as long as you meet the other criteria, and so avoid having to make numerous applications. I know this video has gone on a fair bit, and it may have raised more questions than answers, but hopefully it gives an outline of what is probably the most popular and, if done properly, the most successful route to entry or leave to remain in the United Kingdom. And in particular, it's a route that leads to settlement. And if one gets settlement and has indefinite leave to remain for 12 months to somebody who's got indefinite leave to remain, then one can apply for a British citizenship. If one's married to a British citizen and gets to the end of the 5 years qualifying period, if it's a British citizen, then they can apply for a nationality immediately, having qualified after the 5-year route. I hope this video has been useful, not too long, not too boring. As I say, if you have any questions, please get in touch with me and I'll do my level best to help you. Thank you very much for watching. Do stay safe. This is Paul Turner, the Immigration Barrister at Imperium Chambers.